Hello, I'm attorney Vince Davis. Today we are discussing the most significant changes to California criminal law in decades. The 2024 and 2025 legislative sessions have completely transformed the legal landscape, shifting toward tougher penalties for specific crimes. Starting in early 2025, California has implemented a massive 10-bill package specifically targeting organized retail theft and professional shoplifting. One of the most powerful new tools for prosecutors is AB 1779, which allows for cross-jurisdictional charging across different counties. This means multiple theft offenses committed in different jurisdictions can now be consolidated into a single court proceeding, increasing pressure on defendants. Additionally, AB 2943 now permits the aggregation of stolen property values to hit the $950 felony threshold. For auto burglary, the old locked door loophole is gone. Under SB 905, forcible entry is now a wobbler offense. Prosecutors no longer need to prove the vehicle was locked. If there is intent to steal and forcible entry, it counts. Then there is Proposition 36, passed by voters in late 2024. This significantly rolls back parts of the older Proposition 47. It introduces what we call a treatment-mandated felony for those with 2 or more prior convictions for drug possession or theft. Essentially, a third offense for simple theft can now be charged as a felony rather than just a misdemeanor in California. Defendants who plead guilty to these new felonies can have charges dismissed, but only after completing a rigorous court-ordered treatment program. Proposition 36 also increases prison sentences for organized retail theft involving 3 or more people, or thefts exceeding $50,000. The law is more complex now than it has ever been. Missing a single procedural deadline or misinterpreting a new statute can be devastating. Under AB 701, weight-based enhancements can add anywhere from 3 to 25 extra years to a sentence for large quantities. Courts must now provide the Alexandra's Law advisement, warning dealers that continued distribution leading to death could result in murder charges. This is a dramatic shift in how drug cases are prosecuted in California. You need to understand these stakes immediately. In domestic violence law, the statute of limitations for corporal injury on a spouse has been significantly extended. As of 2025, the time frame for prosecution under Penal Code 273.5 has moved from 5 years to a full 7 years. Furthermore, AB 2308 has increased the maximum duration for restraining orders in domestic violence cases from 10 to 15 years. SB 1394 now addresses tech abuse, forcing car manufacturers to terminate remote access to vehicles if a victim has a protective order. There are also major procedural reforms, such as the introduction of race-blind charging under Penal Code Section 741. Prosecuting agencies must now redact race and ethnicity information from police reports before making an initial charging decision to avoid bias. Judges also have expanded authority under AB 600 to recall and modify sentences to align with these newer, fairer laws. This allows the court to update older sentences without needing the direct consent of the district attorney in many cases. For juveniles, AB 1186 eliminates restitution fines for minors, acknowledging the different financial realities of younger defendants. While direct victim restitution remains, the punitive fines that often burden families are being phased out and become uncollectible. Navigating these changes requires a sophisticated defense strategy that understands both the new tough-on-crime measures and procedural protections. My office is already implementing new defense tactics to counter the aggregation of theft values and the new felony drug mandates. The law is more complex now than it has ever been. Missing a single procedural deadline or misinterpreting a new statute can be devastating. We are committed to ensuring that every client benefits from the latest procedural reforms, like race-blind charging and resentencing discretion. We are reviewing every active case to see if these new judicial powers can be used to modify or reduce existing sentences. If you or a loved one are facing charges in California, you cannot rely on old legal advice. You need counsel that is current. We maintain the highest professional standards, focusing on forensic detail and aggressive advocacy in the California justice system. To summarize, the era of Prop 47 is shifting toward Prop 36, and sentencing for drugs and theft has become significantly more severe. But with those challenges come new procedural rights that we are ready to use to your advantage in the courtroom. Call us now at 888-888-6582. I'm Vince Davis, and we are all in this together.